I don't know who did it, but somebody was so stupid they even got me to side with DA Michael Gravely on an issue. As you know, Michael Gravely is the district attorney that is in charge of the case against Kyle Rittenhouse and Chrystul Kizer. And of course, Chrystul Kizer is a young black female that was arrested for murder. She claimed self-defense, and that has angered a lot of people, including a bunch of morons at Harvard Law School. So we're going to hear a letter from them to Michael Gravely, and it's a real hoot. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
All right, let's take a look and see what we got here.
New at 5, Harvard law students question the ethics of the Kenosha County District Attorney. This comes after the case of a Milwaukee teenager accused of murdering her alleged sex trafficker got national attention. Corrine Zell has the latest as this case awaits trial. Corrine's live in the newsroom with more. Corrine.
Steve, this case is controversial because the teenager accused of murder faces life in prison, but many argue her actions were self-defense.
This is Chrystul Kizer in 2018.
By the way, I think it's kind of ridiculous that she's bundled up like that. I mean, when you see somebody like that in a court, you almost are bound to think that they're guilty of something. I understand they're trying to keep her safe, but that seems to be a bit extreme.
Charged with shooting and killing Randall Volar in his Kenosha home before setting it on fire. She was 17. At that time, Kenosha County District Attorney Michael Gravely told TMJ4 about a social media post from Kizer. He says shows she planned the crime.
Where she is essentially bragging on a Facebook Live sort of telecast. She has a gun in her hand. She's waving that gun in her hand.
Yeah, that stuff doesn't bother me so much. There is some other evidence that has come out that might indicate she did plan the actual murders.
And she is discussing how if somebody makes her mad, she'll shoot them like she shot someone previously, and there are people there trying to quiet her down.
In a criminal complaint, Kizer says she could not leave without being blocked, and she believed that Mr. Volar might jump out at her, so she shot him.
Yeah, okay, so that's a lot weaker than what I had originally heard. My original impression was that he was in the actual act of raping her at the time when she shot him. And that's the reason why I think that they have moved away from any kind of claim that she acted in self-defense because she feared great bodily injury, but rather they're jumped on this other part of the legal statute that refers to a safe harbor law. And I'm a little skeptical that that strategy is going to work. And I have another video on that, and I'll put it in the description below.
Kizer is now 19. In a recent interview from jail with the Washington Post, Kizer says she acted in self-defense and claims Volar had been trafficking her for sex for almost 2 years. In response, support for Kizer poured in from all over the country, asking the DA to drop the charges. This petition alone is signed by more than 122,000 people. Last month, the DA took to Facebook and asked those interested in the case to reserve judgment until the facts are presented in court at trial. The Post went on to say the DA's office was working on a case against Volar at the time of his death, but says Kizer never indicated that she was trafficked by Volar and said they met on Backpage and he paid her for sex. Over the weekend at a women's march in Milwaukee, Kizer's mom asked for an investigation into the DA's office.
We will also be shining a light on the DA of Kenosha County, Michael Gravely, for trying to sweep this matter under the rug.
Now Harvard Law School's National Lawyers Guild is getting involved, sending this letter to Gravely that says in part, "Your conduct in the Chrystul Kizer case is a cause of concern to us," and asked the DA to bring his conduct in line with professional standards by dropping charges. All eyes on Kenosha as both sides get ready for this case to take the national spotlight.
Okay, we're going to read that letter from Harvard, and it's a doozy. You know, it's a perfect example of what happens when you lower admission standards, and possibly what happens when you don't have a faculty advisor that's giving you some advice on how to conduct yourselves. So let's take a look. And here we go. And by the way, this is one of the worst website designs I've seen in quite a while. But, okay, that's neither here nor there. The National Lawyers Guild, Harvard Law School Chapter, a student-run organization at Harvard Law School. Okay, here we go. Open letter to Kenosha DA Michael Gravely. And they even have a hashtag, Free Chrystul. So there's no ambiguity whatsoever about where they're coming from. Hello, DA Michael Gravely. Hello? Okay, kind of a strange salutation, but whatever. I am writing on behalf of the Harvard Law School National Lawyers Guild because your conduct in the Chrystul Kizer case is a cause of concern to us. Okay, now it starts out, I am writing. So who is this person? Well, let's take a look. It is sincerely the Harvard Law School National Lawyers Guild. So I is the Harvard Law School National Lawyers Guild? Maybe this is some strange new pronoun deal where you use the plural pronoun for people, right? You've been seeing that coming around lately. And now you use the singular pronoun for plural. Okay, I don't know. We call your attention to the American Bar Association's ethical guidelines for the prosecution function, and in particular to Standard 3, 1.2, B through D. And of course, this is just a bunch of students trying to look important here. I'm not going to read all this. Your actions to date in the Chrystul Kizer case stand in grave breach of these professional responsibilities. Chrystul was a 17-year-old girl when she killed a 34-year-old man who had been raping and physically abusing her. And you know that they were just dying to put black girl and white man in there, but they probably thought about it a little bit and thought, yeah, that's gone a little too far. Who had been raping and physically abusing her. She deserves empathy, sympathy, and support for the horrible abuse she suffered at the hands of a grown man, not criminalization. Sound discretion and justice in this case would clearly look like dropping the charges. Wait, let's go back and read this again. Listen to the English. Listen to the English in this. Sound discretion and justice in this case would clearly look like dropping the charges so she can move on with her life and recovery. You have a duty to improve and seek reform for the prosecutor's office, not to go to extreme lengths to prosecute cases that do not belong in the courthouse to begin with. A nice dangling preposition there. So they're basically lawyers explaining to a district attorney, these are students. Your insistence on prosecuting the case against the plan language, meaning of the safe harbor law is bizarre and negligent. Bizarre and negligent. It seems to come from a place of racist fear of Chrystul. She really looks real scary there. She probably weighs about 110 pounds wet. A young black woman, and should have no place in the administration of the prosecutorial power. Oh, good grief. Now, the safe harbor law that they're talking about, basically in Wisconsin, they had an assembly bill that they tried to pass. It didn't, but the language of the bill was cast into another statute that basically states that if you are a victim of sex trafficking, then those crimes that arose because of your sex trafficking cannot be levied against you. All right? I don't believe that it was ever meant to allow people to kill other people. And the judge in the case has agreed that that's not the way that safe harbor was supposed to be applied. Okay? So the idea that come along and saying the plain language meaning of the safe harbor law is bizarre and negligent. No, we read the safe harbor law in one of my previous videos. It's pretty clear, in my opinion, that safe harbor law was not meant actually to allow people to kill each other. It was really meant for those kind of crimes like drug charges and stuff that arose because a pimp basically forced his prostitute to engage in criminal behavior. And so we may be wrong. You know, DA Gravely might have it wrong, and it's going to appeals court now, and the appeals court might overturn that earlier judge's decision. But it's certainly not bizarre and negligent to believe that the safe harbor law doesn't apply to murder. And the idea of calling it plain language meaning? Give me a break. The judge doesn't buy it. They're appealing it. Can't be too plain language if they're going back and forth. We encourage you to bring your conduct in line with professional standards by interpreting the safe harbor law to provide broad protections to minor survivors of sexual violence. By dropping charges against Chrystul Kizer and by developing just departmental policies for the handling of the cases of criminalized survivors of sexual violence and domestic abuse. They want all the charges dropped. What about the arson? I mean, she tried to burn the house down. She admitted that. And you're going to drop those charges too? What about stealing his car? Well, okay, unauthorized use of it. Keep in mind, Randall Volar, who is sort of like the pimp in this deal when it comes to the safe harbor deal, he didn't tell her to burn the house down. He didn't coerce her into doing that as part of a sex trafficking activity. It was his house. And the same thing with taking the car. So even if you think that she's innocent of first-degree intentional homicide, she still has other charges they can at least try her for. They want the charges dropped completely. Gee, I wonder what they think of Kyle Rittenhouse being on videotape, being chased by people and attacked. I bet you that they are perfectly okay with Michael Gravely pursuing charges against Kyle. Why? You know why. And then it says at the bottom, support the Free Chrystul movement on Facebook at Free Chrystul Kizer. I don't know if that went out to Michael Gravely or not. I have a feeling he's probably not getting on Facebook and supporting the Free Chrystul movement. Oh, I forgot. There's one last sentence, and it's a great one. This should be done post-haste. Actually, that's one word. To avoid further damage to your professional reputation and the potential for ABA sanction. Holy cow. Okay, first of all, you want people to do things for the right reason, not to protect professional reputations. That was a terrible thing to say. You know, you really should drop the case of Chrystul Kizer because this just looks bad for you. What kind of argument is that? And then the potential for ABA sanction? By what right do they have to mention anything about ABA sanctions in here? These are a bunch of students at Harvard. They have no authority to speak for the ABA. Okay, so I decided to look into the old National Lawyers Guild to see a little bit more about what they're about. All right, here we go. The National Lawyers Guild. The National Lawyers Guild is dedicated to answering the call for fundamental change in the structure of our political and economic system. Okay, you're starting to get the impression, aren't you? It seeks to unite lawyers, law students, legal workers, and jailhouse lawyers to function as an effective force in the service of the people. The NLG brings together those look upon the law. The NLG brings together those look upon the law as an instrument. Oh, good grief. For the protection of the people rather than for their repression. You know, the welcome part of your webpage probably should be proofread a little. The HLS chapter of the National Lawyers Guild is an association of law students dedicated to the support and defense of social, political, and economic justice, here we go, and to progressive change rather than the acceptance and perpetuation of the status quo. Marxism. We are an explicitly abolitionist organization. Hey, John Brown, here we go. With an aim to educate and agitate for abolitionist, non-reformist reforms. What the hell's a non-reformist reform? Oh, man. And by the way, an explicitly abolitionist organization with an aim to educate and agitate for abolitionist, non-reformist reforms. Okay, what are they about abolishing? Slavery? You strive to use legal education and practice to help create a world that is free of oppression. Activities the NLG is working on for next year include providing support for protesters through a jail support hotline and legal observers. Yeah, this is Black Lives Matter, a disorientation workshop for incoming students, because we don't want students to be oriented towards anything when they come in. They have to be disoriented. And by disoriented, that means all the values that your parents gave you, you need to get rid of those, because we're going to now infuse you with new values. Street law clinic workshops on workers' rights, housing and immigrants' rights in local communities. Legal observing at protests. Coordinating and staffing the jail support hotline for protesters. Yeah, see what I mean? This is all about BLM. Building community with like-minded students and lawyers. So, yep, the standards for admission, got to lower those down, and this is what you get. But it gets worse. Okay, so we go to the Harvard Crimson. This is the Harvard student newspaper. Okay. Law school students criticize Wisconsin prosecutor in open letter. Oh, okay, this is spicy. We know what the letter says. Okay, so I'm going to skip down. All right. Shortly after, Kizer allegedly shot Volar twice, lit his body on fire, and fled the scene in his BMW. Hey, Harvard Crimson, you're supposed to be journalists. You should know. Randall Volar's body was not set on fire. The law school student's letter, which now is singular, so it looks like it was written by a student who doesn't seem to have the nerve to disclose his name or her name, called Gravely's decision to prosecute Kizer a cause for concern and a breach of professional responsibilities. Okay, I'm going to skip down. In a Monday interview, this is where it gets good, Gravely disputed the research National Lawyers Guild students had conducted on the case. Yeah, if they thought that Chrystul Kizer burned a body, I think I would be disputing that as well. He said the students did not contact him for information prior to disseminating the letter, so they didn't even ask him about evidence and what was going on in the case or anything. That's just irresponsible. And believe me, I'm no fan of Michael Gravely. I think he's a real horse's ass. But he's right. From my perspective, if you accuse an attorney of being unethical, that's kind of the professional equivalent of accusing someone of a crime, he said. Yeah, that is about right. I would suggest that before you use an esteemed university's name, ooh, that hurt, and before you cast judgment on the ethics of an attorney, that the least you can do is be sure you've diligently investigated all sides. Okay, so this is what happens. The National Lawyers Guild, they hear all of this stuff coming in from the social media and the news media. They get all fired up because they're pretty much BLM protesters, okay? They don't do any research to find out if what is being said is true or not. And we all know what happens when that happens, right, with Kyle Rittenhouse. And they get all steamed up, they get worked up, and they create this letter. And they send it to him. The letter is unprofessional, it's poorly written, and frankly, it should never have seen the light of day. Now, let's read on. The authors of the open letter declined to comment. Okay, so you're going to write an open letter to Michael Gravely, and then when he responds, you're not going to comment to an open letter? What was the point of writing an open letter? I mean, if you're going to play this game, you should have sent him a private letter. All right. The letter also criticized Gravely's interpretation of Wisconsin's safe harbor law, which protects victims of human trafficking from criminal charges related to their abuse. Kizer's defense argued this protection should apply to the arson and homicide charges in this case. Okay. And it says here, in the letter, your insistence on prosecuting the case against the plan sick language meaning of the safe harbor law is bizarre and negligent, the letter reads. It seems to come from a place of racist fear of Chrystul, a young black woman, and should have no place in the administration of the prosecutorial power. We read that. Gravely said the law has never been used to defend violent crimes, and that it only offers protection for crimes directly related to sexual abuse, such as prostitution. So in other words, And I went over this in one of my previous videos. We read it in real detail here. And the whole idea that Michael Gravely's take on this is bizarre and negligent is itself bizarre and negligent. And a judge agreed with Gravely. Okay, now it's being appealed. It may come back in favor of Chrystul. Frankly, I don't think it will. I think that the Harvard scholars that wrote this letter didn't read the actual statute. Okay, so what is it about? And I'll post a link to the actual video where I went over this in detail. But essentially, it goes like this. Let's suppose I'm a pimp, okay, and I got my prostitute, and I need her to go run drugs for me, okay? She's a minor, for example. And because she's undergoing sexual abuse, I am going to make her run these drugs for me, and she gets busted, okay? If the drug use was a part of the sexual trafficking, in other words, you can tie the drug possession to the actual sex trafficking in some way, then that might prevent the police from prosecuting her because it was tied to sex trafficking. The most common use of this is in the actual prostitution itself. So in other words, if you're a prostitute for me and I can be accused of sex trafficking, then the prostitution laws don't apply to her. Okay? That's what it's meant for. What Chrystul Kizer is claiming, and of course this is coming from her lawyer, who I think is kind of a dingbat. I mean, I can't believe that they're trying this particular strategy, but maybe it'll work. But what they're saying is that Chrystul killing Randall Volar should fall under safe harbor. And I don't see that at all. I don't get it. For example, the arson. She tried to burn the house down. How is that related to the sex trafficking? What about the stealing of the car? Or actually it's unauthorized use. And again, I don't know how the appeals court's going to come back on this, but I don't think they're going to defend Chrystul Kizer on this. I have a feeling that they're going to say, look, that if she acted in self-defense, then she needs to apply the elements of self-defense to her case. And I have a feeling that Chrystul Kizer can't. And I think the problem with Chrystul Kizer's self-defense claim is that she shot Randall Volar at a time when she was not being physically threatened. Part of self-defense is that the threat has to be imminent. And so, for example, I can't do a preemptive strike against somebody. I think that somebody's going to hurt me, so I go out there and shoot them first. Can't do that. I also can't do revenge. So if I get hurt badly, I can't go and seek the person, shoot him, and then claim self-defense. And I have a feeling the problem is that he wasn't physically attacking her at the time. And so I think that they may not be able to claim the regular self-defense, and therefore they're going after the safe harbor deal. I'm not sure. I really can't know for sure. But I do know a lot more about it, I have a feeling, than the people at the National Lawyers Guild, who don't seem to have done their homework. It goes on. The trial court judge disagreed with the defense on that issue, he said. This is not an interpretation of the safe harbor law that has happened before in Wisconsin. And so for the National Lawyers Guild to come in and say that his reading of the safe harbor law is bizarre and negligent when a judge actually agreed with him, boy, that is really ballsy and frankly unprofessional. So there you have it. It takes a lot to get me to side with Michael Gravely on an issue, but a bunch of dingbat students from Harvard managed to do it. They need to learn their place. They have no business getting involved in this. They certainly have no business getting involved when they haven't done their homework. However you feel about Chrystul Kizer and her self-defense claim, there's certainly enough evidence for her to go to trial. I mean, she carried the gun to his house. She got an Uber, put a gun in her house, and went to his home. She tried to burn evidence after she got done. She took his car. She even texted her brother, told him that she had a car for him. And so you stack all that up and you think, well, it could be self-defense. She was a victim of sex trafficking, it appears. But it might not be. She might have planned this. And I think that it's okay for a jury to hear this. Now, I'll put a link below. If you want to donate to her defense, I applaud that. Good. She needs the best defense she can get. But at the same time, if she's guilty of these crimes, she needs to be tried, and if convicted, punished accordingly. Now, I understand as a victim of self-trafficking, those are mitigating circumstances. They can be taken into account in the sentencing. They can be taken. The judge can take those into account during sentencing. But you simply say she's a victim of sex trafficking, therefore she has a license to kill, that's going too far. And I have a feeling that the appeals court is going to make that claim. That if you are willing to allow people to get away with killing others because you were trafficked by them, then there's going to be bloodshed. No matter what you say about Randall Volar. And I'll tell you what, man, there's not many people willing to say anything good about him. Maybe his mother. And I know that some people out there think that he deserves to die for what he did, but not at the hands of Chrystul. We'll have the trial. We'll see the evidence. But I think it's preposterous to just simply drop charges against her, given what we know. Like my video and subscribe to my channel.